All right, hello, welcome back. Today we're going to talk about criminal defenses. Over the last couple of days, you had been learning about crimes against the person as well as crimes against property. So, crimes against the person refers to crimes that occur to a person's physical body. Whenever the law refers to the word person, it's talking about a body. Some examples of crimes against the person would be first degree murder, second degree murder, voluntary manslaughter, involuntary manslaughter, sexual assault, and anything that can happen to a person's body. You had also read about crimes against property. These are crimes that don't occur to a person's body, rather, these are crimes that violate other people's property rights. So, examples of crimes against property would be vandalism, arson, forgery, embezzlement, carjacking, things that occur to physical property. What we're going to be talking about today is criminal defenses. So, for conviction, as you are already aware, a prosecutor needs to establish that a defendant had committed an act beyond a reasonable doubt. That's the standard of proof in criminal law, beyond a reasonable doubt. And as we had talked about in our Elements of Crime lecture, all elements of a crime need to be proven beyond a reasonable doubt. So if one element is missing, a crime still may have been committed, but it wasn't that specific crime that they are being charged with. So if you have a pickpocket that is walking down the halls of Elgin High School and that pickpocket slips their hand in your backpack and takes out your Chromebook and walks the other direction with your Chromebook, can they be convicted of robbery? The answer is no, because if robbery is defined as the taking and carrying away of goods or money from a person with force or intimidation, they had taken goods or money, a Chromebook would be a good, from your person. They took it right off of your body as you're walking down the hallway, but they didn't use force or intimidation. Does that mean that that student would be completely innocent? No. It's, of course, larceny, but it's not robbery. So, anyways, back to this. So, for conviction, a prosecutor must establish that the defendant committed an act beyond a reasonable doubt. The defendant does not need to present a defense in court because remember, in our criminal justice system, you are innocent until proven guilty. Who proves you guilty? Well, the prosecutor, the government, proves you guilty. You don't have to present a defense in court. You can do the equivalent of just sitting back and then shutting your mouth and say, hey, you're the one that is convicted or that's charging me with a crime. You accused me of this. You prove it. You don't have to help the government prove that you had committed a crime, and you don't have to defend yourself in court. The burden of proof is on the government. So, even though you don't have to defend yourself in court, there are some options available to defendants. So, today we're going to talk about what some of those options are. The first option is no crime has been committed. This is the defendant claiming that there was no crime that was done. There's two versions of this. One, that there was no criminal act committed, or two, that no criminal intent was involved. So let's start with the first one, this idea of no criminal act was committed. If in the state of Illinois you are walking down the street and you are carrying a concealed weapon, concealed meaning hidden weapon, in the waistband of your pants, and a police officer pulls you over and then performs a stop and frisk and pats you down, feels the gun, goes, aha, we got you, you're carrying a weapon, and then they arrest you, charge you with a crime. You can say, well, no criminal act was committed if you have a valid license for that gun. Illinois is a concealed carry state. So if you have a valid firearm owner's identification card, which is known as a FOID card, then you can say that, yeah, no, I was carrying a gun on me, but I have a license to carry a gun on me. So there is no crime. The other version of this defense is no criminal intent was involved. So let's take the crime of rape. If you have a defendant is accused of rape, that defendant can prove that no criminal or no crime had been committed if they can demonstrate that there was consent on the victim's, the alleged victim's part. So in that case, there would be no criminal intent because there was consensual sexual intercourse and therefore making it not a crime. Another example of this is a defendant that may claim to have mistakenly taken another person's coat. If you mistakenly take another person's coat, there was no guilty state of mind, and therefore it's not a crime. It was a genuine accident. Another defense that is available to defendants is that the defendant did not commit the crime. So oftentimes there's no doubt that exists that a crime has been committed, but often the question is, well, okay, who did it? So a defendant might present evidence of a mistake in an identity or offer up an alibi. So this idea of a mistaken identity is, hey, you're charging me with this crime, but perhaps the video footage that you're using is grainy and it looks like me, but it's not me. It's a mistaken identity. Or if there was a witness there that swears that you had committed the crime, but you look very similar to the actual perpetrator, that would be another example of a mistake in identity. What you can also offer up is this idea of an alibi. An alibi is evidence that the defendant was somewhere else at the time of the crime. So if you were charged with a crime at 12:30 on a Wednesday, what evidence you can use to demonstrate that you did not commit that crime is the attendance that I take during our law class. If I mark you present, that is the teacher vouching for the fact that you were in class at that time and you couldn't have possibly have been shoplifting at Target. Another example of the defense of defendant did not commit the crime is DNA evidence. DNA evidence has made it possible to connect an offender conclusively to a crime, and vice versa. DNA evidence has made it possible to exonerate a defendant of a crime. To exonerate means to clear them of criminal responsibility. So if a defendant is able to gain access to the DNA, the fingerprints that were left at a crime, and then show that those fingerprints do not match their own fingerprints, that would be an effective way to show that a crime has been committed, but this defendant did not commit the crime. Another defense is an excusable or justifiable act. So in this case, an act has been committed, something was done by you, but you're claiming that you had a valid excuse or that your actions were justifiable, that they were well warranted. So some examples of an excusable or justifiable act would be self-defense, defense of property, or defense of others. So let's start with self-defense. The law recognizes your right to use reasonable force in self-defense. However, you cannot use more force than appears necessary. So, if let's say you are walking to fourth period and another student at the school ends up jumping you from behind, punches you right in the back of the head. If you turn around and then you defend yourself by punching back, you have every right to do that in the state of Illinois. The law recognizes that you were the victim, you were attacked, and you're simply using physical force to defend your own body. But you can't use more force than appears necessary. So if you got hit in the back of the head, you turn around and then you end up knocking the person out cold. That the person that assaulted you is now on the ground, and then you walk over to your locker, take your lock off of your locker, wrap it around your fist, and then start beating their face in while they're unconscious. You're no longer the victim of this crime. You have now become the perpetrator of a crime. So that would be an example of you using more force than was necessary. That initial victim, the person that hit you, was out cold on the ground. They're no longer assaulting you. And when you went and then grabbed a weapon and started assaulting them, you can no longer claim that you're the victim. At that point, you are the perpetrator. Deadly force. Deadly force can usually be used only by a person who reasonably believes that their life is in imminent danger. So in court, you will have to demonstrate that you honestly believe that your life was in imminent danger. If the jury believes that you believe that your life was in imminent danger, then it would go down as an excusable or justifiable act. But the jury's not always convinced that you honestly believe that your life was in imminent danger. So some states, building off of this idea of self-defense and use of deadly self-defense, some states have passed what are known as stand your ground laws. And stand your ground laws give people the right to use deadly force to defend property or themselves against unwarranted intrusion in public. So you can see on this map, it shows that Illinois is not a stand your ground state, but it is. We don't officially have a law on the book called a stand your ground law. And so technically speaking, no, Illinois is not a stand your ground state, but if you look at the precedent that the courts have established, we in de facto are a stand your ground state, which means that if you are in public in a place that you have every right to be, and then somebody comes up from behind you and then threatens your life, let's say that they pull a gun on you and you had a gun in your pocket and you pull out your gun and then defend yourself in public by shooting that person, killing them, in Illinois, that would be justifiable. You are defending yourself in public using deadly force. Now, stand your ground laws can be contrasted with duty to retreat states. So some states are not stand your ground states, but rather they are a duty to retreat state. And these states are states that they say that you have every responsibility to try to retreat or run away from the threat before resorting to deadly force. Illinois, remember, is not one of those states. Illinois says that if somebody comes up to you and then presents an imminent threat to your life, if you have every right to be where you're at, you can use deadly force back. Another version of a stand your ground law would be castle doctrine law. So castle doctrine laws are laws that state that you have the right to defend your property using deadly force if somebody breaks in to your house. Illinois is a castle doctrine state. So if somebody were to break into your house in the state of Illinois, you can use deadly force because they are, by simply breaking into your house, they are presenting a deadly threat to you or your family. Some states are not castle doctrine states and are states that require you as a defendant to prove that you believed that that person presented a deadly threat to your life. In castle doctrine states, you don't have to prove that. All you have to demonstrate is that, hey, that person broke into my house, they weren't supposed to be in my house. You do not need to demonstrate that you believe that your life was in imminent danger or that that person presented an imminent threat to your life. Police. Police can only use deadly force in self-defense when a suspect poses a significant threat of death or bodily harm. So same standard applies to the police. The police can only use deadly force when they believe that their life is in imminent danger. So we're moving on. The next one, the defendant committed the act but is not criminally responsible. So let's start with infancy. So children under the age of 7 are usually considered legally incapable of committing a crime. So you might have a child, let's take this little girl, if she were to get a hold of her mother's gun that her mother had left on the coffee table, and this little girl is playing around with the gun, accidentally shoots and kills her mother, are we going to, as a society, charge this little girl, let's say she's age 6 years old, are we going to charge this little girl with the crime of involuntary manslaughter? No. She's 6. She doesn't know what she's doing. And that's the rationale behind the infancy defense, is that some defendants are just too young to understand what they're doing. Now, where it gets tricky is the age 7 to 14 bracket. So between the ages of 7 and 14, you're usually considered legally incapable of committing a crime, but this presumption could be proven wrong. Some states allow prosecutors the ability to determine whether or not that 7 to 14-year-old should be charged as an adult as opposed to as a juvenile. In fact, there was an infamous case in Florida in which a 12-year-old was charged as an adult for killing his 6-year-old sister. He performed a wrestling move that he had watched on TV on his 6-year-old sister and ended up killing her on accident. Well, this kid was charged as an adult, a 12-year-old, mind you. 12-year-old was charged as an adult and sentenced to life behind bars. This would be an extreme example, of course, but this is an example nonetheless of a prosecutor using their discretion to charge a juvenile as an adult. So some states do not have the infancy defense, and others allow prosecutors to decide whether to try a defendant as an adult. The next defense would be intoxication. So defendants can claim intoxication when, at the time of a crime, they were so drunk or high that they did not know what they were doing. So in general, voluntary intoxication is not a valid defense. So you can't voluntarily get drunk, commit a crime, and then say, well, what are you talking about? I was drunk. Or you can't voluntarily do drugs and then say in court, well, I was on drugs. I didn't know what I was doing, therefore I'm innocent. No, voluntary intoxication would be an example of which you're going to be convicted of the crime nonetheless. However, it may sometimes be valid if the crime requires proof of a specific mental state. So, for example, if a defendant was charged with assault with intent to kill, but claims to be so drunk that she could not have formed the intent to kill. That would be an example in which voluntary intoxication could come into play. So in intoxication, the assault would still stand, but you could be so drunk that you can claim that you couldn't have possibly have formed this desire to kill because you were so blacked out that you would not know what you were doing at the time. So the insanity defense. The insanity defense is very misunderstood in the United States. So let's spend a couple slides talking about insanity. So people who have a mental disease or disorder should not be convicted if they do not know what they are doing or do not know right from wrong. So this is what's known as the MacNaughton Rule. The MacNaughton Rule in law, and not all states recognize the MacNaughton Rule, but the MacNaughton Rule states that if a defendant does not know what they are doing and does not understand right from wrong, then they are considered to be legally insane. So about half of the states in the United States and the federal government do use this standard. So during proceedings, the mental state can be an issue in determining if the defendant, one, is competent enough to stand trial. So do they even know where they're at the time? Are they sane enough to know that they are currently inside of a courtroom? Do they understand what they're being charged with? Another issue is, was the defendant sane at the time of the act? So perhaps this defendant was insane before or insane after, but was sane during the act itself. That might be an issue that is litigated in court. The third issue is, will the defendant be sane after the trial? So we don't want to just be releasing people that are considered legally insane back into the general public after a trial. Likewise, we don't want to be incarcerating people that are legally insane with the general population of inmates. Rather, somebody that is considered to be legally insane should be institutionalized and then kept under proper medical care until they can be properly rehabilitated. So, in most states, 3 verdicts exist. 1, guilty, 2, not guilty, but you already knew that. The third verdict is not guilty by reason of insanity. This last verdict requires an automatic commitment to a mental institution. So if a defendant is claiming that they were legally insane, that they are legally insane, then they can't be found not guilty and then released into the general public. Rather, if you are claiming in court that you are legally insane, then we got to fix you. We got to throw you into a mental institution so that you can be rehabilitated. And this defense usually requires a psychiatrist to testify. I wanted to show you a movie called A Time to Kill. Awesome, awesome movie. But in that movie, you do have a defendant that is claiming not guilty by reason of insanity. Well, what happens in that movie is you have the prosecutor places on the stand, the witness stand, their psychiatrist that is going to claim that no, this defendant was totally sane at the time that they committed their crime. They knew what they were doing. They knew the difference between right and wrong. And then you have the defense psychiatrist, and that psychiatrist is going to get on the witness stand and claim this person did not know what they were doing, did not know the difference between right and wrong, and were legally insane. And ultimately, who decides which psychiatrist is more credible? The jury. The jury is the group of people that determine fact, who was telling the truth and who was not necessarily lying, but who was more believable is how I should put it. So in recent years, some states have developed a new verdict, guilty but mentally ill. About one third of states have this new verdict. This, yes, it's kind of semantics, but in this case, we're talking the word guilty holds the the defendant accountable for their actions, even if they were legally insane. Right here, this is a man. I don't know if you recognize him, but he is uh, the man that shot up the Colorado movie theater. This was several years ago. When he showed up in court, you could he had just oddly colored hair, orange and yellow, and he looked like he had no idea where he was at. He was all bug-eyed and like swaying in his chair. And this is an individual that did claim not guilty by reason of insanity. And this is an important point to make before I move on. The general American public thinks that this insanity defense is often invoked and often successful. It's not. It's just not true. Only about 1% of criminal cases actually use that defense, and of the 1%, very few are successful. So it's very difficult to convince a jury that a defendant is legally insane. All right, the last two that we're going to discuss, duress, and the next one will be necessity. Duress. A person acts under duress when he or she does something as a result of coercion, so kind of pressure, or threat to personal safety. So if an individual lacks the ability to exercise free will, this would be an example of a crime that would have been committed under duress. So the picture I placed here is this man. He's got a mask on, gun in his hand. It seems like he's in this man's car. If he were to order this man to go into the bank and embezzle thousands of dollars for him, this would be an example of a crime that would have occurred under duress. So this man, he's not a criminal. He normally would not be embezzling money if he didn't have a gun pointed at his head. So we don't want to hold this man criminally responsible for the crimes that were committed under intense pressure of or threat to personal safety. It is worth noting that duress is not a defense to homicide. So if you had this man tells this man to go shoot his wife, and he does it, this man can't say, "Oh, but I was under duress." And no, he doesn't get to pick and choose who lives and who dies. You can't kill another person and claim that and claim duress. And the last one is necessity. So defendants can claim necessity when they are compelled to react to a situation that is unavoidable in order to protect life. So, if this man's boat is sinking and you have this man starts throwing overboard this man's property, he can't be charged with destruction of property later on because this man could claim that what he did was a necessity to protect their lives because he was just trying to empty out the boat so that it was lighter and the boat wouldn't sink. This man could successfully claim he needed to do what he did in order to survive. It was a necessity. Once again, necessity is not a defense to homicide. You cannot use that defense if you had killed another human being. All right, that's all I have for you today. Until next time.